Welcome to the International Law Virtual Classroom. This module deals with EU restrictive measures adopted as part of an integrated policy approach combining pressure and engagement to persuade states, individuals, or entities to comply with international obligations. Students open the zip file with the annexes they need for this module. The text of the module is sent to the registered students after the lecture. Restrictive measures, or sanctions, are an essential tool of the EU's common foreign and security policy. Restrictive measures adopted by the EU are fully compliant with obligations under international law, including those pertaining to human rights and fundamental freedoms. Sanctions can target governments of non-EU countries because of their policies, entities such as companies providing the means to conduct the targeted policies, groups or organizations such as terrorist groups, individuals supporting the targeted policies involved in terrorist activities, etc. Sanctions seek to bring about a change in the policy or conduct of those targeted with a view to promoting the objectives of the common foreign and security policy. Sanctions are developed in such a way as to minimize adverse consequences for those not responsible for the policies or actions leading to the adoption of sanctions. In particular, the EU works to minimize the effects on the local civilian population and on legitimate activities in or with the country concerned. Sanctions are thus preventive measures which allow the EU to respond swiftly to political challenges and developments that go against its objectives and values. For instance, sanctions can target terrorism, nuclear proliferation activities, human rights violations, annexation of foreign territory, deliberate destabilization of a sovereign country. Key objectives when adopting sanctions are safeguarding EU's values, fundamental interests and security, preserving peace, consolidating and supporting democracy, the rule of law, human rights and the principles of international law, preventing conflicts and strengthening international security. Sanctions are restrictive measures that are applicable in the EU jurisdiction against governments of non-EU countries, groups or organizations and individuals supporting the targeted policies. Various measures can be taken. For example, individuals may be subjected to asset freeze and the prohibition to make their funds in Europe available to them, or restrictions on their admission on European territory. The EU Sanctions Map provides information on sanctions that are applicable in the EU jurisdiction. Third countries may align with EU decisions on restrictive measures. For example, although Albania is not a member state of the European Union, it aligned with EU decisions on its restrictive measures. The assets of an individual or enterprise listed on the sanction list will be frozen in Europe as well as in Albania. Although individuals may reside outside the European Union and be non-European citizens, European sanctions can be imposed on them, such as freezing their assets in Europe and freezing their bank accounts located in the European Union. Freezing assets means that temporarily the owners cannot dispose of their assets and that third persons and entities are forbidden from making funds available to those listed. Freezing assets should be distinguished from confiscation, whereby the property is taken away permanently from criminals or their accomplices. For example, the EU imposed asset freezing on former President Viktor Yanukovych, suspected of embezzling state funds. It also added persons and entities involved in the construction of the Kerch Bridge to the EU sanctions list. Since March 2014, the EU has progressively imposed restrictive measures against Russia and Russians in response to the destabilization of Ukraine and Crimea. The EU also imposes sanctions for repression and for the 2020 election falsification in Belarus. We will illustrate the sanctions mechanism with the Cadiz judgments of the European Court of Justice against the background of public international law and the requirements to provide sufficient safeguards for human rights. Mr. Cadiz was born in Egypt and became a Saudi resident. He had also assets in the center of Albania. The United Nations Security Council adopted resolutions under Chapter 7 to freeze assets of people and groups associated with the Taliban and Osama bin Laden. In the UN Security Council, Cadiz was identified as a possible supporter of Al-Qaeda by the United Nations Security Council resolutions 1267 and 1333. Therefore, he was singled out for sanctions, in particular for an assets freeze. The European Union adopted regulations to give effect to the UN Security Council resolutions. And on the 19th of October 2001, the Sanctions Committee published on the list the name of Cadiz and his assets were frozen. Listed persons and entities may submit a request to the Council, together with supporting documentation, requesting that the decision to list them be reconsidered. However, most listed persons and entities will have to challenge the Council's decision before the Court of the European Union in accordance with the conditions laid down in the second paragraph of Article 275 and the fourth and sixth paragraphs of Article 263 of the Treaty on the Functioning of the European Union. In response to his listing by the regulation, Cadiz challenged it before the EU courts. He claimed before the European Court of Justice that the regulation should be annulled under Article 263 of the Treaty on the Functioning of the European Union because it had breached his human rights. The Cadiz cases tackled the legal questions of the so-called terrorist sanctions regime. The Court of Justice essentially had to decide whether a United Nations Security Council resolution should enjoy primacy over EU law. The court did not allow for this primacy. The Court of Justice ruled that the European Community judiciary does not have the competence to review the lawfulness of a resolution of an international body. However, the European Community courts review the lawfulness of the community measure implementing a resolution of an international body. The Court of Justice has full review for compliance with these fundamental rights, including the right to property, the right to be heard, the right to an effective legal remedy. The right to be heard does not require the Council to hear the person before placing his name on the list, but it obliges the Council to give the listed persons the opportunity to challenge their inclusion on the sanctions listing or to test the evidentiary basis. The Union recognizes the rights, freedoms and principles set out in the Charter of Fundamental Rights of the European Union. The rights, freedoms and principles in the Charter shall be interpreted in accordance with the general provisions in Title 7 of the Charter, governing its interpretation and application. The Union shall accede to the European Convention for the Protection of Human Rights and Fundamental Freedoms. Fundamental rights, as guaranteed by the European Convention for the Protection of Human Rights and Fundamental Freedoms, and as they result from the constitutional traditions common to the Member States, shall constitute general principles of the Union's law. At first instance, the General Court refused to review the EU regulation because this would amount to a review of the measure of the UN Security Council. The court does not have this competence. Nevertheless, the General Court examined whether the Security Council had respected jus cogens, in particular certain fundamental rights. But the General Court did not find an infringement of this standard. However, in its judgment on appeal, the Court of Justice reviewed the lawfulness of the EU regulation transposing the resolution. The Court's central argument was that the protection of fundamental rights forms part of the very foundations of the Union legal order. Accordingly, all Union measures must be compatible with fundamental rights. The Court reasoned that this does not amount to a review of the lawfulness of the Security Council measures. The review of lawfulness would apply only to the Union Act that gives effect to the international agreement at issue and not to the letter as such. Having established that the review for compliance with fundamental rights was a relatively simple task, Cadiz and the Charity had not been informed on the grounds for the inclusion in the list of individuals and entities subject to the sanctions. Therefore, he had not been able to seek judicial review of these grounds, and consequently his right to be heard as well as his right to effective judicial review had been infringed. The judgments also raised the issue of interplay of EU law and international law. The court followed Advocate General Maduro's opinion, holding that obligations imposed by an international agreement cannot have the effect of prejudicing the constitutional principles of the EC Treaty. Moreover, in this particular context of human rights protection at multi-level systems, the level of protection of fundamental rights, guaranteed by a higher level, in this case the European Union, prevails. The Cadiz saga before the European Union courts continued because the UN Security Council sanctions and their replica in the form of EU regulations are in turn part of national law of EU member states. On the other hand, Cadiz insisted on the rules granting his fundamental rights to property and due process, which are enshrined in the EU system, in the European Convention on Human Rights framework, and in national constitutions. The European Court of Justice had to balance values of civil rights and security. In July 2013, the European Court of Justice upheld the annulment of terrorism designation of Mr. Cadiz and struck down regulations implementing the sanctions regime for failing to comply with his fundamental rights protected by the European legal order. Students are assigned the Cadiz case.